also recording this, and if he is not, Richard, would you start now? And so we'll forward that round if you want to share it with your colleagues. You're welcome to do that. A note about recording: everything I'm saying is correct at the time of the 12th of November 2020. If you're watching it significantly later, things do change, and so things do go out of date. I don't foresee anything happening in the next month or so, but you never know when case law is going to change. I am addressing the law in relation to deprivation of liberty safeguards as of now. You may well be aware that there are changes afoot in terms of the liberty protection safeguards. They have been delayed. They've been approved by Parliament and they were supposed to be in place by now, but partially they'd already been very delayed, and then with the COVID-19 situation. At present, the plan is for them to come into force in April 2020. So this regime that I'm about to talk about remains in place until then. And as things change, I'll probably do some kind of training on that closer to the time. I might mention as we go through things that might change over time, but given that we've got nearly 18 months of this now, same situation, it's right that I address what the law is now. I don't want to confuse things too much by talking about what the law will be in future. So things that I'm going to talk about, first half is going to be what the standard authorization process is. What is the standard authorization? And if you've been doing RPR work for a while, you might find this a little bit DOLS 101 basic training, but it's good to go back to the foundations anyway. And yeah, we'll look at that and we'll build on that. What your duties are as an RPR and when to bring a challenge under Section 21, what other options are available. Second half, we'll be looking at actual court of protection proceedings, both under Section 21A in relation to standard authorizations, but also broader court of protection proceedings. Now, I am aware that people from different advocacy services have different contracts in relation to what they can do in court of protection proceedings. I know that some people are commissioned to act as litigation friend in any circumstance. Some people I know rethink. My understanding of your arrangement is that you can act as litigation friend, but not if you're also RPR. And then we've got some organisations that almost never act as litigation friend, only on a kind of one-off basis. So I'll try and address it so it's helpful to everyone. And we'll be looking at the various steps that take part in court protection proceedings. And we'll have a look at the not so interesting but very important world of legal costs and legal aid at the end. So DOLS has grown up in this country in a bit of a kind of step-by-step fashion. It initially we had court authorised deprivations of liberty. It turned out in 2004 there was a case called Bournewood. People do their PhDs on that specific issue, and I'm going to literally mention it. So there are things that I have to skip over just because of time. And that found a big gap in the way that deprivations of liberty in this country were dealt with, essentially saying, yes, people get sectioned, but where someone lacks capacity in a hospital or care home setting, we didn't have something in place to authorise that. And the European Court of Human Rights said, well, that's not lawful. At which point the standard authorisation, deprivation of liberty safeguards procedure was made and was in place. There was a big explosion in how many of them were granted after the case of Cheshire West in 2014. It's not called Cheshire West, it's called something much, much longer than that, but everyone knows it as Cheshire West, and I'll talk about it a bit more recently. But that broadened out what was considered to be a deprivation of liberty. It was then broadened out further in the case of SRK, which said that even in private settings, there are deprivations of liberty. So if someone just lives with their family, but they're still subject to supervision and control, etc., which I'll go into soon, that is counted as a deprivation of liberty. So it's it's become more pervasive into more settings that I don't think was ever really envisaged in the first place. And so now there are these two separate ways of approving a deprivation of liberty, one being the standard authorization process, which I'll go into in lots of detail, and the other being outside of hospitals and care homes, all other settings. It's still for the Court of Protection to do, and that's by way of COP $11, which is a court form that people have to fill out. So what's a deprivation of liberty? There are various stages to it. The term the acid test comes from the case of Cheshire West, where the Supreme Court in this country said, if someone is subject to continuous supervision and control, and they are not free to leave, that's the two-stage test, that's the acid test, then that is a deprivation of liberty. It doesn't matter whether they're objecting to that. It doesn't matter about the relative normality of their situation, so that they live in a private home with their family. And it doesn't matter that actually it's in their best interests. At the point where you're deciding whether it's a deprivation of liberty, that's a very kind of, it's called the objective test. So it's not about, that's not the best interest test. The words of Lady Hale in that case were, a gilded cage is still a cage. So if you're living in a normal home environment, but you're deprived of your liberty, you might like it there, but you're still deprived of your liberty. Whether it needs authorising or not is then subject to those second 2 points, the last 2 points. Whether the person has capacity to consent. If they have capacity to say, I like this 24-hour care package, and I think I need this 24-hour care package, you don't need someone to stand in their shoes and authorise it for them, because they can do that for themselves. It's where they lack capacity to make that decision that somebody, either by way of standard authorisation in a care home or hospital, or the Court of Protection in other settings, somebody needs to step into their shoes and authorise that deprivation of liberty if it's in their best interest. That is the case where the deprivation of liberty is imputable to the state, and that means that the state either has responsibility for it because they fund the care, for example, or because of public bodies having a positive duty to promote human rights and protect human rights. As soon as a local authority is aware of the deprivation of liberty, it becomes imputable to the state, and it becomes something that they have to do something about. So the standard authorization process, I'm just going to change my screen slightly because I couldn't see the side of my screen there. The standard authorization process is that the managing authority, so the managing authority is the care home or the hospital. The DOLS process is full of just language that doesn't really fit with everyday life. The relevant person and the relevant person's representative and the managing authority. So the managing authority is the care home or hospital. If they are aware that they are depriving someone of their liberty, they fill in a specific form, Form 1, and that goes to the local authority, who is then responsible for a raft of assessments. And if those assessments are positive, they then grant the standard authorization. The 6 tests come from Schedule A1 of the Mental Capacity Act, and they are called the qualifying requirements. The person has to be 18 or over for this, for a standard authorization to be put in place. The Mental Capacity Act actually comes into force at 16, but then there's this gap where DOLS can't go into place in terms of a standard authorization until 18. So under that age, you're looking at Court of Protection authorization. Yes. No refusals requirement. This means that the standard authorization doesn't conflict with something that's being said, either in an advanced decision by the person before they lost capacity, or with the opinion of a deputy or an attorney. So if they're saying, no, I don't think this person should be deprived of their liberty in X care home, then the standard authorization can't be granted. that's all I'm going to say about those two requirements, because I think they're relatively straightforward. There's then 4 more that I'm going to go into a little bit more detail about: mental health, mental capacity, best interests, and eligibility. So mental health and mental capacity I'll deal with together. Mental health requirement is that the person has a mental disorder as defined in the Mental Health Act rather than the Mental Capacity Act. And that's a very broad definition. And that plays into the first stage of the mental capacity requirement. And so in order for a standard authorization to be put in place, it has to be considered that the person lacks capacity in relation to whether to be accommodated at the relevant hospital or care home for the purposes of being given the relevant care. That is the wording of the standard authorization. 2-stage test is, firstly, do they have an impairment of the mind or brain? And so that is, again, very broad. It can relate to brain injury. It can relate to cognitive impairments like dementia, mental health diagnoses, learning disability, and it is not necessarily static. People's capacity changes over time, either because their condition progressively worsens, as is often the case with dementia, or in other cases where they have treatment and rehabilitation and actually they have improvements. The second stage of the mental capacity test is what you're able to do. So can you understand the relevant information to the decision, retain that information, weigh it up and use it? So what are the pros and cons? And at the end of that process, communicate your decision. And that relates to the relevant information about the decision at hand. So in terms of things like care, it's relevant information includes, for example, what are the risks if you don't receive care? And so those are the mental health and the mental capacity requirements. In terms of the best interest requirements, this comes from the considerations that are at Section 4 of the Mental Capacity Act. And it talks about, so is it in P being the term that's used within the Court of Protection to refer to the individual at the heart of it all. It's protected patient. It's the relevant person in relation to the standard authorization. Is it in their best interests to be a detained resident? And in order to consider this, you've got to think about what their wishes and feelings were in the past, what their wishes and feelings are now. And that's not just in terms of things they say, it's in terms of the way they behave as well. Their beliefs and values, and any other factors that they might consider if they were, if they had capacity. That can be things like safety, it can be things like finances, it can be things like wanting to spend time with family members, it can be location, all kinds of things. It's a very catch-all term. When considering best interests, you're looking at consulting with the person themselves, obviously, and that's part of this wishes and feelings exercise. And then a named individual, so anyone that they have said I would want them to be talked to in relation to my best interests. Deputy or attorney, so deputy being appointed by the Court of Protection to make decisions either about care, welfare or about property and affairs, or attorney being appointed by the person themselves before they lacked capacity. They need to be consulted. And then another catch-all, which is any person engaged in their care or interested in their well-being. So family members, social workers, professional carers, it can be lots of different people. And that's if practicable, they should be consulted. Usually it's practicable. When considering whether the deprivation of liberty is necessary, is in their best interests, you're looking at whether it's necessary in order to prevent harm to that person. It's not about harm to others, it's about harm to that person. And whether the deprivation of liberty is a proportionate response to the likelihood and seriousness of harm to them. When looking at best interests, it's important to look at whether the proposed care is the least restrictive it can be. What section 1.6 says, which is the least restrictive principle, is that regard must be had to this. It doesn't say that you have to follow it, but if there is a less restrictive option, then it should be followed. There are times where, unfortunately, there isn't, and there are times where there is a restrictive option, a less restrictive option, but unfortunately, no one will pay for it, and I will talk about that a bit more. The biggest and most obvious example there is someone's locked up in a care home, and would it be less restrictive for them to have care at home, really? And so we'll talk about that a little bit more too. The eligibility requirement is about how the standard authorization process rubs up against the Mental Health Act. And if you have ever tried to read this part of Schedule A1 of the Mental Capacity Act and you have found it difficult, you're not alone, because it's really, really badly written and quite confusing. So I've tried to just distill it down into this table. And so what the eligibility requirement does is it breaks down 5 different types of, I suppose, compulsion or relationship to the Mental Health Act. And most of them are actually quite simple when you boil them down. So if you are detained in hospital under the Mental Health Act, you are not eligible for a standard authorization. It's black and white. If under case B, you are actually liable to be detained under the Mental Health Act, but you're on leave, a standard authorization can be put in place, but it can't require you to do something different to the section of the Mental Health Act. A couple of common examples are, one, where someone is coming to the end of their detention under Section 3, for example, of the Mental Health Act, and they're looking at discharge to a place where they would be deprived of their liberty. And they go for some leave there to try it out, make sure they're okay, make sure they settle there. A standard authorization can be put in place at that place to deprive them of their liberty there. And that all works hand in hand. If the person's still supposed to be living at the hospital, a standard authorization couldn't be put in place for them to be deprived of their liberty elsewhere. A different example is where someone is detained under the Mental Health Act. They need to go to a general hospital for some, I don't know, surgery, physical treatment, and they are going to be deprived of their liberty at that different hospital. It's not a psychiatric hospital, so that the Mental Health Act can't be used. The standard authorizations sometimes are used there, and they don't clash either. Cases C and D, same kind of thing. If you're subject to a community treatment order or guardianship under the standard authorization, under the Mental Health Act, then a standard authorization can be granted as long as it doesn't have a clash with those provisions of the Mental Health Act. Case E is the most complicated one, and it's really confusing when you read it, but essentially what it says is, if you meet the criteria for detention under the Mental Health Act, but you're not detained, so you are, that's my word, not the Mental Capacity Act word, you are sectionable, then you are not eligible for a standard authorization. So if you are a patient in a mental health hospital and you object to that, you should be sectioned under the Mental Health Act. You shouldn't be deprived of your liberty under a standard authorization. I have come across difficult cases where essentially a standard authorization is in place. The treating psychiatrist in the hospital says, no, they're not sectionable, where everyone else kind of says, I think they probably are. And you know that if that standard authorization were removed, the doctor would have no hesitation in sectioning that person. So they are difficult cases where someone maybe falls down a gap in the middle, but but if someone's saying they should be under the Mental Health Act, then they shouldn't be also under the Mental Capacity Act. I am going to stop there and stop sharing my screen. Has anyone got any questions at this stage? I'm going to scroll through here and see if I can see any hands raised. I cannot, and I can't see any physical hand raised. If you are wanting to ask a question now and I haven't spotted you, do feel free to just switch off your microphone and shout at me. Otherwise, I will continue. So we've looked at, and it's useful for me to have a quick look at the time as well. We've looked at, I don't think you can see that. Share my screen again, technology. We've looked at what a standard authorization is, when it can be put in place, when it should be put in place. I'm going to talk about your role. I'm going to have a drink of tea. I'm going to talk about your role within that standard authorization, and I'm going to talk about how that leads to you challenging the standard authorization or asking that it gets reviewed. So someone doesn't have to have a professional paid RPR. They can have an unpaid RPR. It's quite common, I think, for family members to be the relevant person's representative. I have to say, I don't come across them very often, despite the fact I know they exist. And I think that's because they tend to be put in place where people are relatively settled and not really objecting. And so they don't come to me because I only get involved where it becomes contentious. I hope that's the case. Otherwise, there are lots of family members acting as RPR and hearing objections and not bringing cases under section 21A where they should be, which I think is also the case. And I think that's why caution should be exercised when consideration is given to who should be RPR, because family members can find it quite difficult, and understandably, to separate their own views from the need to protect the person's rights. They might think, well, okay, they're objecting, but it's right for them to be in this care home. They'd be in danger at home. They can't step out of that necessarily and bring a challenge on that person's behalf. That's not always the case. I have come across family members that can do that, but I find it quite rare, and I don't think that's a fault of the family member. I just think it's natural. So I think it's right that in those circumstances, people like you are appointed. What's your role? It's not my job to tell you what your job is, but it's really to support the individual in all matters that arise out of the standard authorization. And a lot of that, again, I don't get involved in, because unless it's going to court or you need some legal advice, you're doing the job on the ground. So you probably know better than I am, but it's the effect of the standard authorization. You know, this document, this authorization, means that you can't just up and leave it, and working with them to help them the best they can to understand that. Monitoring the conditions. So there can be conditions. And it's interesting because I did some training probably 2 years ago with an advocacy service where I said, I don't know how useful conditions are. And a number of RPRs said to me, we use the conditions all the time. We wave it around in front of people's faces to say, look, this is what the law, the deprivation of liberty is authorized on this basis. And I was quite heartened to hear that. And so I was wrong and they were right. Monitoring care home records to see if there are problems there that the person themselves isn't raising issues. This can be things that seem really small, perhaps to really busy carers. Again, possibly because they're stretched and no fault of their own. But it's a huge thing. If you, for example, if I couldn't find my glasses every day, I'd just be lost. And so I've seen RPRs, you know, where's this person's hearing aid? Where's this person's glasses? Different, like I say, things that are seemingly small but make a big difference to someone's life. Making their voice heard about things that they like and don't like, things they want to do, things that can improve their life. Bringing complaints where complaints need to be brought. And then challenging the standard authorization where it's right to do so. And that can be either by a review or by an application to the Court of Protection under section 21A of the Mental Capacity Act. A review is available at any time. It is under Part 8 of Schedule 1A, A1, and it can be triggered by either the care home itself, so the managing authority, the person at the heart of it all, so the relevant person, the person in the care home, can do this themselves. It's rare, but I have come across it where I've got a client in North Tyneside who rang the DOLS team and just said, no, I want this reviewed. It didn't unfortunately lead to them moving, but it does happen. And then you as relevant person's representative, I've said it too many times, this is to review whether the qualifying requirements, so they're the 6 tests that we talked about, no one's going to change their age all of a sudden, but if you found out that there's a deputy that says they shouldn't be in the care home, if you think they've recovered capacity, you think that it's not the least restrictive option for some reason anymore, you can ask for that to be reviewed or to review the conditions that are in place. My understanding, and again, this isn't something I get very involved in, but my understanding is there's not a specific way that you can do this. You can just write to email the DOLS team and say, I think this needs reviewed for various reasons. I would say you need to be careful in when you bring a review or when you consider Section 21A, and I am going to come to that in a second once I've talked about both. When are you bringing a challenge under Section 21A? First thing I want to say about this is everybody talks about Section 21A being a challenge to this standard authorization or arising out of an objection. And that's not what it says in Section 21A of the Mental Capacity Act. It is the main reason that they occur is that the person says, I don't want to be in the care home, and so it is challenged on their behalf. But it doesn't have to be that. What Section 21A says is that the court can determine any question about whether the relevant person meets one of those 6 tests, the qualifying requirement, the period of the standard authorization, the purpose of it, and the conditions. So actually, you're not obliged to wait for the person to object if you think that that standard authorization is not in their best interests. Talking about when to bring a review and when to bring Section 21A challenges, I'm still using the term challenge despite what I've just said because it's so pervasive. But yeah, let's just call it that. This is an important case which you may well be aware of. The first paragraph here, fifthly, there's a whole list of stuff in there, doesn't relate to when to bring a challenge, but it does relate to what I said earlier, and I thought it was useful to just highlight it in relation to the difficulties of close relatives or friends in being RPR and bringing those challenges. It's been recognised by the court that that is tough and that care should be taken in who is the best person to be appointed to the role of RPR. But this is what I wanted to talk about just now. The court says that advocates, it refers in this case to an IMCA under 39D, but it applies equally to RPRs. Act with diligence and urgency. And earlier on in the case, it talks about if public bodies and if nobody brings a case before the court under Section 21A, the wording that the case uses is something like the person's rights evaporate. So it's pressure on you guys. It's really saying if someone's objecting to where they are, then, oh no, it says it there, evaporation of their rights. If someone's objecting, then the court needs to be looking at this. Where there is a clear objection, I would say, fair enough, there are times when a review under Part 8 is appropriate, but where there is an objection coming from the person, it should be the judge that's looking at this, really. This was considered further in this case, re-RD, long name there, And there's a useful flowchart here, which was produced by Victoria Butler-Cole QC, who is a barrister at 39 Essex Chambers. And I don't very often put links into these things, so I'm really, really hopeful that this flowchart's going to come up. Take a second. If I were you, I would print this off and I would keep it somewhere. We're going to circulate these slides and I've put the link in there. She's done, I think, a really clear job, and she did this a few years ago, of when to bring a challenge under section 21A. Does the person have, unfortunately I can't, I was going to try and put it all on one slide, but it was just too small to read, so I'm going to just scroll through it. Does the person have capacity to decide whether to issue proceedings? If actually you think this person has capacity to decide that for themselves, then you don't have to make the decision. They're making the decision, then they're asking you to do that. It's not a high threshold, so it's not saying that they have to be able to conduct the court proceedings. It's just saying they understand that a judge can be asked to decide whether they stay there, and that's all they need to understand. What happens within the proceedings, they don't have to understand. It's just start the proceedings. So if they do understand that, then yes, you should be bringing the proceedings. If they don't, does the person express a consistent wish? Oh, I'm just getting something in the chat. Oh, hang on. I'm being told. Could everyone see that flowchart there? Well, I thank you very much for bringing that up, whoever just sent me that message. I'm going to try that again and see whether that's something that I've done. Somehow I've managed to unshare my screen, so let me, not that. I apologize, give me 1 second while I just find it. Can someone just send me something on the chat to say whether you can see that?
Yeah, I can see it.
Excellent, thank you very much. Thank you, April. Lovely, and thank you for not all just sitting there and wondering what the hell was going on, because that would have been very embarrassing. So here's the flow chart. This is what I was just saying. Does the person have capacity to that low level? If they do, yeah, ask them. If they want to bring court proceedings, then bring court proceedings. If you think they don't, do they consistently say they want to challenge that standard authorization? Yes, well then issue court proceedings. If they don't, you have to then think a little bit more abstractly, I suppose. Does their behaviour indicate, I'm looking here, does P wish to apply to court, taking account of what they say and how they behave? Are they always at the door of the care home trying to leave? Are they packing their bags every day? Are they saying, I hate it here, but they don't really understand what a judge does? Or sometimes you mention, the number of times we mention court proceedings, or I say, I'm a solicitor, first thing that people say, I've done nothing wrong. And they automatically jump to the criminal court in their head. Someone says they've done something wrong. They might just not be able to get there in their heads. So it's then for you to say, well, taking into account what they're doing, do they want to challenge it? Often that is going to be a yes. If it's not a yes, if they could express an informed view, would they wish to? So that can be looking at if you think one of those qualifying requirements no longer applies. All of this, you follow it through. If you think it's in their best interests for you to issue proceedings, it's still a yes. If not, if you can still come to a no here, you don't have to issue court proceedings. But the rest of the time, it's a yes. I get contacted by RPRs quite regularly who say, I think I should be issuing proceedings. What do you think? If you think you should be issuing proceedings, the answer is yes, really. And you need to do that within the caution that the judge has expressed about diligence and urgency. What I would say is by the time we get down here, where the person's not actually objecting, so their behaviour doesn't suggest that, but perhaps you think that the qualifying requirements aren't met, it's here that I think it's probably appropriate to ask for a review before you issue proceedings. And I think that's a proportionate and an appropriate thing to do if either by what they say or by what they do, there is an objection to the deprivation of liberty. I'm not convinced that their rights are properly protected by asking the local authority who granted it in the first place to review that standard authorisation. My view is that if you are in these territory, you should just be going straight to the court. If it's the fact that you think the qualifying requirements have fallen away, but the person themselves isn't objecting, then perhaps review first. I am always happy to discuss that with you if you want to. I would say I can't think of a time where an RPR has contacted me and I've just said, no, don't do anything. I can think of a couple of times where I have said, yeah, it's okay, but go through the review process first, but mostly not. And now I need to work out how to get my slides back. Can you see my slide there, April? I'm relying on you.
Yes. Oh, question marks just come up. Is that right?
Excellent, excellent.
Yeah.
So there we go. I've stopped sharing that. Anytime, any questions at this stage about when you should bring one? My view is this is a fundamental human right, not to be deprived of your liberty inappropriately. And if you are, that you have that swift recourse to the court. And that comes from the European Convention on Human Rights. It's not just my view. And so my view is very much, if in doubt, bring it under Section 21A. I've never taken one to court and been criticised for it. I can tell you quickly about a case that I did in the summer where an RPR contacted me to say that their client was essentially in the last days of his life. Everyone was expecting him to unfortunately pass away because of the COVID restrictions. And let's be honest, because of the difficult relationship between his best friend and the care home staff. The care home staff weren't allowing her in to spend time with him in his last days of his life. He had always been settled in the care home. He had a very good relationship with his friend, and his friend said she had always told him that she would be there when he eventually passed away. They had a very close relationship, and she and this was after all of that guidance that came out from the government that said, okay, tight restrictions in care homes, but you can visit where someone is at the end stages of their life. And so we took an urgent challenge. I sent the papers into court probably within 12 hours of being contacted by the RPR. On the basis, I mean, there wasn't time for a review in this case. He wasn't objecting. He didn't have any idea really what was going on. But on the basis that that standard authorization had always met the qualifying requirements. But at this time, it was no longer in line with that least restrictive principle, which feeds into the best interest requirement. We said that had fallen away. It never got before a judge. I sent it urgently to the court. The local authority came right on side. The social worker rang the care home and some negotiations took place. And his friend was there when he died. And I was very, very glad for all you can be glad in those circumstances that was worked out. But there was no, and the legal aid agency paid the bill for that case. And if it's not right, the legal aid agency won't pay the bill. So I am confident that that was an absolutely appropriate use of Section 21A, despite the fact the guy never uttered an objection. So I'm just looking as to whether anybody's got a hand up, and I can't see any. I'd love a question at some point, just so it's not just me. But we will move on, and I will work out yet again the slide sharing. So we've got, we've talked about what a standard authorization is. We've talked about when to challenge it. And now I want to talk about what happens when you get into court. And this can be in various different situations. And there are three main ways that I think, I can't think of another way it would be before the court of protection. In a welfare case, I am not covering today anything to do with property and finances. That is a whole other world, which if you want me to talk about sometime, I will. But we're talking about health and welfare and deprivation of liberty. The first way is the way we've just talked about. So that is Section 21A of the Mental Capacity Act, known as a Doll's challenge, and the court's considering those qualifying requirements. Usually it's brought on behalf of the person in the care home because they're objecting, but not always, as we've said. And in those circumstances, I'm going to talk about legal aid more at the end, but in those circumstances, the person is eligible for legal aid no matter what their means are. So they can be a millionaire, they're deprived of their liberty in the care home and they don't want to be there, and they get legal aid as a matter of course. Sections 15 and 16 of the Mental Capacity Act are really broad sections, and it just allows the court to make declarations. For example, this person lacks capacity, and to make orders. For example, they should move from X place to X place, or they should have certain treatment, or they should not be allowed contact with a certain person. So sections 15 and 16 really broad, and the rest, if they're not section 21A challenges, the rest are brought under section 15 and 16. And that's split down into two ways. One is community deprivation of liberty authorizations. So where a standard authorization isn't available, because the person's not in a care home, not in a hospital, they are, for example, in an independent supported living placement, they are at home with their family, anywhere. That deprivation still needs authorization if all of those tests we've talked about in terms of, you know, continuous supervision and control, they lack capacity, they can't leave, etc. Still needs authorizing. And that's done by the Court of Protection through the non-contentious process. So that's the COP $11 form that usually the local authority is responsible for filling in, unless they have healthcare funding. So if they've got continuing healthcare funding, it becomes the responsibility of the CCG to make the application. That can only be done where the person's not objecting and there's no dispute about what's in their best interests. It can't be done if it's a contentious case. So they need to have a Rule 1.2 representative, which is analogous to the RPR role, but in community DOL setting. Again, some advocacy services are commissioned to do that and some aren't. And I know that many aren't. It's also possible to have an accredited legal representative. That's people like me who are accredited by the Law Society, but we don't do a lot of that work because of funding issues and because it's unnecessary often for a lawyer to be involved in that. I haven't put on there family members, and often the Rule 1.2 representative is a family member where it's non-contentious. I think the same things still apply that I said earlier, in that they may find it difficult to raise objections on the person's behalf, but I think it happens more often, mostly because there's fewer advocacy services funded to do the Rule 1.2 representative role than there are to do the RPR role. And then the third way is contentious court of protection proceedings. So that's to say, anything else that comes before the court where there's a contest about a dispute about where the person should live or what care they should receive, or the safeguarding concerns and the local authority or somebody thinks there should be restrictions on contact with a certain person, financial decisions again falls into a different part of the court of protection, but they do come before the court. Serious medical treatment, withdrawal of clinically assisted, artificial nutrition and hydration, withdrawal of treatment, surgery decisions, whether the person has capacity at all, that can be very contentious. So some people might be saying they do, some people will be saying they don't, and it's for the court to determine that. Whether they have capacity to get married, to consent to sexual relations. It can go into all areas of someone's life. There are cases about whether they have capacity to engage in certain religious practices like fasting and hair removal and things like that. So it's very broad. Often cases are brought under section 15 or 16, and where there's a standard authorization in place, the court will make an order which essentially says this case is reconstituted under section 21A. So to say this is all being heard under that umbrella of section 21A, and that's a funding decision really, because of that non-means tested legal aid that people get in section 21A that they don't get otherwise. I'll talk about that more later. This is the only slide I've got on the non-contentious deprivation of liberty authorizations. Application is made by the public body, usually local authority, but sometimes CCG, on the basis that the person's deprived of their liberty and that needs to be authorised. This can be either because that public body is funding the care directly, and so it's clear that they are responsible for it, that is, the deprivation of liberty is imputable to the state, or it can be because there's a private care package that the local authority has become aware of. They've been notified that this person is deprived of their liberty, and then they are under an authorization, an obligation to bring that before the court. There should be a Rule 1.2 representative appointed, either family member or professional, to raise the person's voice within the proceedings. I think I've put a link there to the COP-11 form. If you ever want to have a look at it, you've probably seen one. It's a really, really long form, and it addresses all of the same kinds of things that are addressed in the standard authorization process, but it talks about what the care package is going to be. Is there going to be any restraint? What is the care what's the care package going to look like? Where they're going to live? What's the ratio of care home of staff to patient, and all of that kind of thing. If it is a truly non-contentious matter, it'll be dealt with on the papers by the Court of Protection in London, which takes ages to deal with things, who will look through and check all of things. And I don't want to quite use the word rubber stamp, but they approve it on the papers. And there's no need for anyone to go to court. Sometimes it's not as straightforward as that, and it's more contentious than either the local authority thought when it issued the case, or they just haven't picked up on something that perhaps they should have done, or things have changed in the consultation process. If there is a dispute or an objection, the Court of Protection in London will look at it and transfer it to the regional court for it to then be fed into the contentious pathway, which is what I'm going to talk about quite a lot after this. If the Rule 1.2 representative looks at it and thinks actually this person's objecting on the basis of what they are doing on a daily basis, they hate it, they're objecting, so then it needs to get transferred, and that needs to be reviewed on an annual basis, which involves the local authority paying the court fee every year, going through the same processes of consultation. Part of the deprivation of liberty reforms is that the plan is that the two pathways the standard authorization and then this non-contentious in the community DOL pathway are going to be merged together so that there's a bit of continuity, which I think makes a lot of sense. And so that should change when we get into 2022, but as things stand, this is where we are. For some reason I can't move my slide on. Just got a message in the chat. April has very kindly just shared the link to that flowchart in the chat. So if you just want to copy that now, you can do that. This is where I'm going to talk about contentious court of protection proceedings, and this is what you'll be involved in quite a lot of. This is either where it started because the person is objecting, or for some other reason, someone thought the qualifying requirements don't apply, so an application is brought under section 21A, or where the local authority or CCG starts a case because they think there is a dispute about one of those issues that I talked about before: contact, care, welfare, all those things. So the first thing that happens is someone actually sends the papers to the court. So that's the court forms and probably some supporting statements, or at least a breakdown of what the case is about. That can either be done, if you are the RPR, you instruct a solicitor, you take it to someone like us who can draft those forms and send it off to court. At this stage, you will be thinking about what your involvement in that case is. So are you able to act as a litigation friend? Do you have to allow someone else to step in and act as a litigation friend? The other way it can start is by the public body, so the local authority or CCG sending the application into court. It will then be listed in the court for an initial hearing, which, unless otherwise agreed, is an attended hearing. And the first orders, certainly in deprivation of liberty, section 21A applications, tend to be agreed between the parties, and they're not exactly the same, but they tend to be looking at similar things. So what evidence do we need? Do we need another assessment of the capacity? Do we think that that's got holes in it? Do we think actually our client's got capacity? Do we think we need almost always a statement from the allocated social worker addressing, you know, what was done to keep this person at home? Is it possible to have a care package at home? Is this care home meeting their needs? Is there another care home that would be better for them? Would they be better in independent supported living? All those things that we can be asked, we can be asking. P's representation, so who's going to represent them in the court? Who's going to be their litigation friend? Who the parties are going to be? Is there a family member who needs to be added as a separate party in proceedings? Certainly if there's any prospect that there's going to be restrictions on contact with that person, they should be added as a party to proceedings. They might have strong opinions. Family members know more about the case usually than any of us, and it's appropriate that the court hears from them. If the parties can agree those initial orders, for setting a timetable for what evidence is going to be provided and what happens next, then that hearing doesn't have to go ahead, and the parties will agree the orders, send them to the court, and that will be vacated. So it's not to say the court isn't involved. The court just deals with it on the papers and people don't have to go. I think there's a feeling sometimes that hearings get vacated all over the place, so nothing's happening. What it means is the parties have agreed what should happen next. Even if they can't agree the end point, they agree what evidence we need to reach that end point. And so there's no point in having a court hearing if you can agree that between yourselves and ask for the court's approval. Often at the first hearing, in fact, almost always, we'd be getting a third-party disclosure order so that we can get the records from the care home, or we'd get directions for the disclosure of adult social care records and any other health or social care records we think are appropriate to help inform us. And And what will happen then is it'll be listed for a further hearing down the line once that evidence has been provided. So it's for the parties to agree that timescale and then for the court to set the date. What kind of evidence are we looking at? I mean, I've addressed some of this really. What capacity evidence? Section 49 report is under Section 49 of the Mental Capacity Act. You can get a report from the various different public bodies, very often the NHS. And it's often used for a capacity update or where the initial capacity evidence was flawed or that there's been huge changes to the person's presentation, they've made improvements, or that certain points weren't addressed. So the capacity evidence at the outset looked at the care and residence points that are needed for the standard authorisation, but actually there's an issue about contact and there's no evidence before the court about whether the person can make that decision for themselves. There's quite a lot of delay in getting Section 49 reports at the moment because of, I mean, they're always relatively slow. They often take about 8 weeks. But at the moment, the pressure's on the NHS. Some trusts just aren't doing them. So you could be looking at an independent psychiatrist or psychologist to provide that evidence. Equally best interests evidence, so you're looking at witness statements from the social workers, all those extracts of records that I've already talked about. Potential expert evidence, so independent social worker, if there are disputes to be resolved, occupational therapist, nursing, and some of that can be obtained under Section 49. So Section 49 is not just about capacity evidence, although it's commonly used to get capacity evidence. If there is a treating occupational therapist who could comment on the person's home or whether they're fit to travel if they want to move quite far away, then you could use Section 49 for that, or you could be looking at independent evidence. Sometimes the local authority has their own people, occupational therapists and things, so they would just provide that evidence. Look at what records are needed, as I've said. And as the case continues, you can get quite a long way through a contentious court protection case without having to attend a hearing, and that is not wrong. You should never agree to something that's not in your client's best interests, but if you can agree the timetable, then the judge has finite time. It's good for the parties to work together, but there is a line where you just say, no, we can't agree to that. We think we need an expert capacity assessment, and the local authority says, no, we're not contributing to the costs of that. You go to court and you have a contested short directions hearing where the parties make submissions to the judge and the judge decides. As cases go on, you'll often find that the issues narrow and they may not need determination by the judge at a final hearing. And the reasons for this are numerous. Firstly, if you get either expert evidence or just other evidence. So if you get a social worker statement that exhibits a care plan that shows very much that this person is not going to be able to manage at home without 24-hour care, and if you get evidence, for example, that there was a huge amount of effort to keep that person at home before they were deprived of their liberty, it may be that you just, the parties make concessions along the line to realise we don't have a case to pursue that. Equally, you get an expert report that says this person has capacity and the local authority reads it, they might challenge it, or they might say, no, we agree, standard authorisation comes to an end, you both agree in order, you send it to the court, and that's the end of the proceedings. So there are various times where proceedings can fall away, either because it's become apparent that the arguments you were running weren't possible because the local authority makes a concession. Yes, okay, we'll do a home trial, and that home trial goes well and the person stays there. So it can work both ways, and it's important to walk the line between working with the other parties. It's not contentious like some litigation is, because you're not talking about winners and losers, you're talking about capacity and best interests. However, it's also important to stand up for your client and make sure that their case is properly put. Fact-finding hearings. So we have cases, for example, where the local authority wants to put restrictions on contact with a person on the basis of allegations against that person. And actually the person, be it relative or friend or partner, denies those allegations. And so what has to be done is schedule of what those allegations are. The person has the right to respond to those allegations. And then if that dispute remains, there's cross-examination of the parties, and the judge decides what the facts of the case are. So on X date, did so-and-so hold a knife to this person? Did they stop them leaving the house? And they will be then known within the court proceedings as facts. So no longer these concerns or allegations. Best interest decisions will then be made based on those facts that the judge has decided. Other ways to try and narrow the issues are round table meetings, get everyone in the same room, or these days on the same screen, and talk things out. And often you will find that you can compromise, or you can deal with certain issues without a determination of the judge. If you can't, it still goes before the court. Advocates meetings, that generally means the legal advocates in the place, so the solicitors and barristers that are involved getting together and saying, well, I was in one a little while ago where there was a fact-finding hearing due to take place, and the local authority's evidence was, I think I would use the word shoddy, and they were really pushing for this woman to go into a 24-hour supported living placement with 2-to-1, I think, care. It might have been 1-to-1. And there were allegations. I was acting for a family member. Her partner, he absolutely denied the allegations, and the council had provided very little in terms of details, even as to what date things are supposed to have happened on. And there was just, I thought, very little way that they were going to prove that. So the meeting between the lawyers was very much us going, are you really going to ask the judge to decide that? Because we don't think you're going to get that. And in the end, they didn't on that occasion. And actually, in the end, there was an expert report that said she had capacity across all of the areas, and they were pushing on an interim basis to get her into a very restrictive care package. So that was a case where we were really pushing back, whereas other times you can compromise and concede certain points. At the bottom there, I say about available options. So the Court of Protection stands in the shoes of the individual concerned, and they choose between the options that are available to them. This was considered by the Supreme Court in, I think, 2016, I might be wrong about that, in a case called N versus ACCG. Lots of Court of Protection cases are very anonymised, and it becomes quite difficult to remember what they're called. But what the court said is the Court of Protection isn't there to make funding decisions. So what they have to do is look at what the options are on the table at the time and choose between them. Which of those options is in the person's best interests? So we, representing P, cannot say, well, local authority, we know that this person's in a care home and they require 24-hour care. We actually think that they should go home and that you should pay for one-on-one 24-hour care on a 24-hour basis, because the local authority has no obligation to do that. The local authority has an obligation to meet that person's needs. Unfortunately, that means that they can meet those needs in a care home setting if that is what's affordable. What this does mean is if someone has a lot of money, there are more available options on the table. which can be frustrating, but it's not for the court of protection to make funding decisions. There are ways of challenging funding decisions outside of the court of protection if they are unlawful. So that is by way of judicial review. What you will often find, though, is you may not like the funding decision, but it may not be an unlawful decision. So if they are saying, well, we'll pay for your care, but we'll pay for it in a care home, we're not going to provide 24-hour care at home, that's a lawful decision. And unfortunately, it's unlikely that you would therefore find a way of challenging that in the administrative court separately by way of judicial review. So there are times where the narrowing of the issues is just entirely frustrated by what is actually available. And although the court is allowed to stand in the person's shoes and not make funding decisions, what the court can do is make directions for rigorous probing of what those options are. And so the court can say to the social worker, well, you haven't addressed these options properly, go away, and I want a further statement that says why these options aren't available or how it could be worked differently. So it's not, the local authority just can't keep saying, no, no, no. I had a case where the local authority was saying, no, we wouldn't pay for him going to this placement. But they also said he needed nursing care, and they had never, ever really backed up their case to tell me why he needed nursing care. But they'd set the parameters of the search of other options to nursing care. So eventually, after asking lots of times, we got an independent social workers report to look at this and look at what the actual available options were, because the local authority, we said to the judge, and the judge accepted on that occasion, wasn't properly fulfilling its job in providing those options to the court. So there are lots of ways to investigate available options, but if an option truly isn't available, the court can't choose from it. What happens next? Why aren't my slides moving on? Just going to stop sharing my screen for a second because for some reason my slides are not moving on. There we go. So other things that can be done, interim positions and testing of those interim positions. In terms of capacity, the person might have been, for example, assessed as lacking capacity to make a certain decision at the outset of the case. And it's not that you think there are flaws in that capacity assessment at the time, but there may be ways that that person can develop capacity or attain capacity. Could be there are classic example, person is assessed as lacking capacity to make decisions about sexual relations and consent to that, and actually through a course of specialist learning disability appropriate sex education, actually the person can understand more and understand the basics, and it's really all you need, because in terms of capacity to consent to sex, the case law shows that it's got quite a low threshold. You don't need really detailed information. So it might be that through a program of education, that person can reach a point where they make decisions for themselves. And that means the Court of Protection can't make decisions for them, the same as they can't for me or you. It might be that using speech and language therapy enhances the person's understanding and enhances the person's communication to a point where actually they reach capacity and they can make that decision for themselves. Again, the court can't make the decision for them. So it might be that you have a capacity assessment and then a direction from the court to say these things should happen, and then a reassessment a few months later, found to have capacity, and that's the end of the case. In terms of interim positions about best interests, where the person does lack capacity, Can a care package be put in place? I know we have one person on the line where I was dealing with this only the last few days. To mitigate the risks where they are. So the council says staying at home is too risky and they need to go in a care home. Well, actually, could you put in a package of domiciliary care to mitigate those risks? And that's a less restrictive option, and test that for a few weeks and see how that goes. Actually, if it goes well, it might be that the case fizzles out almost because things are going well. They don't need to go into a care home. It might be that there are there's supervised contact with someone for a while if there are concerns about that. And as time goes on, they then get, I don't know, the supervisor, whoever that is, carer, social worker, no longer sits in the room. They sit outside so they can see, but they can't hear. And then they get a little bit of time on their own. And then next step is they get to go out on their own, and actually bit by bit, it becomes less restrictive and contact is resumed. And so that's another way that kind of interim positions can be tested out and moved slowly along. These things do take time. Another that you may have come across is a trial. So either the current care home or wherever they are isn't meeting their needs. There's a better place for them to go. There's an independent supported living placement they could go. They could go home to their family with a package of care going in a few times a day. So let's put that in place. And sometimes you can agree that with the local authority, put it in place for a couple of months, let's say 6 weeks, a trial, and then see how it goes. If it goes well, again, there can come a point where an order is agreed and the case ends. Sometimes it goes very badly and the local authority ends up making an emergency application to come back to court, or sometimes it just doesn't go well enough that people think it can continue. Sometimes it goes all right and they think, well, actually one more care visit a day and that would be okay, that kind of thing. This is hampered by the available options because a trial is only really considered a full-on trial, I suppose, where the placement at the care home is kept open, and that involves convincing the local authority to fund the place at the care home for the trial period and the domiciliary care package at home or the other care package wherever else the trial takes place. It does happen, but some local authorities just refuse. It's a bit of a postcode lottery, if I'm honest. If when you have gone through further evidence, further roundtable meetings, compromises, concessions, trials, education, all of those things, and the parties can't agree, then you go to trial. Most cases don't. Most cases resolve somewhere along the way. There might be a contested hearing, a day's contested hearing halfway through about whether a home trial should take place. And then whoever is successful in that, if the home trial does take place, actually it doesn't need a trial at the end. Sometimes cases have to go all the way and there's a 3-5 day hearing, whatever it is, where everybody, social workers, carers, family members, give evidence and the judge makes a decision about whether the person's got capacity and what's in their best interests. One thing to always be thinking about is how P themselves is represented throughout this process. And I'm going to talk about that shortly. I've got about 15 minutes. I said it would be done within an hour and a half, and I'm on course to do that, really. Any questions at this stage? Haha, Heather. Gonna unmute, no,
I've muted myself.
There we go.
I want to put a scenario to you if I can. Basically, there are two individuals. One lives in a registered care home, one's in independent supported living. They want to be together. Court of Protection has gone in for the one in the independent supported living to see whether there can be a trial period for them to go into stay within the registered care home. There's concerns about whether the relationship you know, they think it's a bit one-sided and it's all in favour of the person who's in the registered care home. But actually, if the woman in the independent supported living has capacity, and wants to go, should it be going into court of protection at all?
Do they, have you seen capacity assessments for both of them? Are you aware of the capacity position?
I haven't. I'm the advocate for the person in the registered care, but they keep saying, I know they've got capacity around finance and all sorts. So it's, yeah, sorry, what was the question?
Just whether they've both got capacity, but you don't know if the partner in the independent supported living placement has capacity.
Around having sexual relationships? No, I don't. But that would be the only scenario then, because if they did have capacity, because I was under the impression it was something to do with her being in independent supported living and then going into registered care to live with this person. But actually I've since found out that her existing tenancy will stay the same. She'll still be considered there and just visiting. So I'm just interested as to what scenario, whereas court of protection...
Complicated, and I don't think I know enough. I'm keen to stay on track time-wise.
Okay.
We'll put up my contact details at the end, and you're welcome to just give me a call and chat it through if you want to.
Okay.
I would say it really depends on whether the partner in the independent supported living placement has capacity or not. I have cases where, I have one case where I act for husband, and he's in a care home at the moment with his wife. They are both assessed as lacking capacity, and there are two sets of court of protection proceedings running alongside of each other with cross disclosure, and the hearings all taking place at the same time. And so if they both lack capacity, the court is then in a very complicated situation of balancing their best interests against each other, because actually one person may be at risk from the other. It may not be in their best, I don't know, it may not be in their best interest to live together, but the other person may really want that and is not at risk. And so it would then be a balancing act of both of those things, and it would be sensible for the court to hear them both together. If the person in the independent supported living placement has capacity, then really you're only talking about the court considering the person in the registered care home and what's in their best interests. But what's in their best interests, although their partner can choose whether to live with them or not, only if that's available and in their best interest, because actually the court might say it's not in your best interest to live with that person and for them to come and live with you. So I would need more information to give proper advice about it. It's quite complicated.
No, I think my bottom question was just basically if that person had capacity to say they wanted to stay with the other person, then that would not they wouldn't need to go through court protection. But you're saying actually there might be.
So if I was saying I want to live with my partner and my partner said I don't want you here, then I couldn't live with them essentially. And so the analogy would be where the person can't say I don't want to live with you, the court of protection might say it's not in my best interests to live with you. So that person then can't choose that because the court's put restrictions on their contact.
Okay, thank you.
But like I say, I probably don't know enough about the wider situation. But if you want to give me a call, I'm very happy to talk it through.
Thank you.
Right. For the last section. There we go. How is P represented? So we've talked about all of the things that can be done. How is P involved? P being your client who is in the care home or elsewhere, who is said to lack capacity, and they need to be represented. So who needs a litigation friend? Children do, because they can't instruct solicitors and conduct court proceedings. I'm not going to talk at all anymore about that. What I am going to talk about is adults lacking capacity to conduct court proceedings. They are the protected party within the court proceedings, and this is where you or I or someone else gets involved. The criteria to act as someone's litigation friend and stand in their shoes and conduct the proceedings for them, instruct their lawyers, and decide what you think evidence is needed. The criteria is really wide and says you can't have a conflicting interest. You have to be able to act fairly and competently. You have to be willing to act. So you can't be told to act as litigation friend if you're not willing to do so. The conflicting interest thing, again, brings in the issue about family members. Family members very regularly, I think, we deal sometimes with clients, not in my welfare work, but in our property and affairs department, where they've had a catastrophic injury up to acquired a brain injury, and they're going through personal injury proceedings about that, big money claims really, but they lack capacity to conduct those claims. It's quite common in those situations for family members to act as litigation friend. Not as much in court of protection proceedings, because where families are involved, there's often the same thing I was talking about in terms of litigation friend. So either they can't separate themselves enough to be independent, or actually they have really strong views and they should be a separate party to proceedings, and P should be represented independently. So advocates act as litigation friend, as you know. Family members, there is a case, and it's called it's UF, it's called, where the court talks about family members can be appointed, and having a strong view about P's best interest doesn't necessarily stop you from being appointed as litigation friend. But you have to be able to show that you can act in what the court says is an even-handed manner, step out of your own opinion and look at all of the options. Again, no criticism of family members, but that can be hard to do. If you really think my mum's going to be really in danger if she goes home, it's hard to step out of that. Where there's nobody else, the official solicitor steps in, the official solicitor being a kind of arm's length government body, publicly funded, to act in and act as litigation friend of last resort. So if there is somebody else who's appropriate and willing to act, the official solicitor won't. The other way, which is relatively new, came in 2017, I think, is accredited legal representatives. That is me and other people like me who have gone through a Law Society accreditation to act in a strange hybrid role of solicitor and litigation friend. So usually where a solicitor acts, they are instructed by someone. I act for clients where I am not instructed by anyone, but I take into account the person's wishes and feelings, and I speak to their advocate, and then I decide how I think the proceedings should progress, and I have to be appointed by the court in order to do that. What does a litigation friend, or indeed accredited legal representative, do? Everything that P would do themselves in court proceedings if they had capacity to do so. So that is conducting the court proceedings. It's really a twofold role. One is to conduct the court proceedings in P's best interests, and the other is to make sure the court is aware of what P's wishes and feelings are. And now the two don't always go hand in hand, and I think you can end up in quite a conflicted situation where P has very strong wishes and feelings, but it's really obvious that it's not in their best interest. So there are times where you are saying to the court, well, they think this thing, but actually I'm asking the court to do this thing. And that's allowed as litigation friend. I know that it doesn't always sit comfortably with advocates because you are very much trained to raise P's voice. And that's difficult, I think, sometimes. it's important that you make sure P is involved in the proceedings to the best they can be or the best they want to be. So sometimes that's just about writing to the court with information that you've gleaned from them. Sometimes it's about arranging meetings with the judge, and often that'll be done in conjunction with the solicitor, who will do a lot of those things. P can attend court. Special arrangements need to be made so they're not in the melee of all the weird court stuff and waiting around and all of that. Sometimes a judge will go out to see them. I've recently had a couple of video calls with the judge and a person in a care home, but it's been really tough during lockdown to make sure that the person's as involved as they can be. There's some really good guidance about that, and actually when we send the slides round, I will add that in. And responsibility for the payment of costs, that does not mean that out of your pocket you should be paying for P's costs, but it does mean that you can sign legal aid forms, you can give authority for contributions to legal aid, you can sign if you at the beginning of the case when a litigation friend is appointed. Often, very often, the court will make a financial order which gives you certain powers, which include signing direct debits and things like that to allow money, if the person isn't eligible for legal aid, money to be released from their bank account and that kind of thing, which I know is difficult and doesn't always sit comfortably, but you should be doing that in line with legal advice and not just on your own. There are responsibilities to act in a reasonable way and not end up wasting costs within the court. But really, my understanding is if you are commissioned as litigation friend, then you have a certain level of insurance in place. But you should always be taking legal advice where it's necessary anyway. So I would hope that you wouldn't end up in any difficulties. How are you appointed as litigation friend? Either the court just invites you and appoints you. You can apply. You can use the specific COP form to say, I believe this person lacks capacity. I'm an appropriate person to act and I'm willing to. Or you can initiate the proceedings. So where it's a standard authorization challenge under section 21A, be one of the first things in the first order, who's going to act for P. Do you need to instruct a lawyer? I would say in contentious proceedings, yes. I can't think of a time where it would be appropriate not to. If there are difficulties and costs, then you should be talking to lawyers about how you get around that. But really, they're either eligible for legal aid, or there are times where people end up paying for their own legal costs, despite the fact they're in a situation where they never asked to be, really, which is not morally a very difficult thing, but that is the system we work within. In non-contentious proceedings, perhaps not, because is there any risk? I've just had a question. Is there any risk of costs award against the litigation friend, and how do you prevent it? There is, if you act in an unreasonable way. So take advice, don't act unreasonably. It's very rare, I'll be honest. Wasted costs orders, for example, where you've taken something to court where you could have agreed it. So when I was talking earlier about vacating hearings and agreeing the next steps, if you've been really unreasonable and actually the court says this should never have come before me, and the local authority says, why have you dragged us to court when it was clear that this was unnecessary, there is a risk of a local authority making a wasted costs application and the court making a wasted costs order. It's highly unlikely, if you are following your solicitor's advice, that that's going to happen. And I usually, when you end up before the court, it's because there is a real issue that needs to be dealt with. So there is a risk. Often you would be looking at legal aid. Actually, within the costs, because you will say to the legal aid agency, I don't think that this was wasted costs. And I would say, again, there is, if you are commissioned, then there should be insurance in place within your organisation. That's my understanding of the situation. So I hope that covers it. If not, Carolyn, do raise your hand at the end and we can discuss it further. How I've gone through how to be appointed. Yeah, instructing a lawyer, do it in contentious proceedings. That would be a way where you could end up in a very difficult situation where you're doing things that you don't necessarily understand, and there's no reason to get there because there are solicitors who can help you with that. In non-contentious proceedings, actually, it really depends, and often I would say not. If you're in any doubt, ring a friendly solicitor and ask whether it's something that they can take on. And one of the reasons I am saying this is real problems. Moving my slides on. Legal aid. And so there are three main tests, I suppose, to getting legal aid in place. One is that the case is within the scope of legal aid. So actually, legal aid is available in that area where there's a dispute about someone's deprivation of liberty or a dispute about their care, well-being. It's within the scope. You don't have any difficulties. Property and affairs matters, it's not. So if you ever get involved in that, you'll find that legal aid isn't available. There's a means test. Well, yeah, so the second kind of test is that they are eligible in terms of means, either on a non-means tested basis because they're deprived of their liberty and the case is proceeding under section 21A, in which case things are very straightforward, or under a means tested legal aid. And so that is where you may find, and I know this again morally doesn't sit very well when you're looking at a dispute about someone who is subject to restraint. They didn't ask for those things to happen, but it may be that on a means test, they have to make a contribution towards their legal aid. If they have more than £3,000 in the bank, they're likely to have to make a capital contribution to their legal aid. If it goes above £8,000 in the bank, they're just not eligible. And I know that that is sometimes the case, that they have quite a lot of money in the bank because their benefits are managed by the council and it's been accrued, and it's just, it's not right, but it is the way of the world, unfortunately. Or if they have a certain level of monthly income, it may be that they have to make monthly contributions. I come across them more often where it's a one-off lump sum at the beginning. And then the third test that you have to pass in order to get legal aid is a merits test. So does this case warrant the use of legal aid where someone is deprived of their liberty and they're objecting? Again, it's very, I can't think of a time where you wouldn't be granted legal aid for that. Except that where it's a non-contentious case, there aren't any legal issues hugely that you need to take advice on. If there are contentious matters arising, then it's on the wrong pathway and it shouldn't be in the non-contentious pathway. It should be transferred into the contentious pathway in the local court. And so there are, just to go back a slide, in terms of should you instruct a lawyer in non-contentious proceedings, you may find that that option's not open to you because the person's not eligible for legal aid. Nobody thinks that it's in their best interest to spend money really for you to get advice to go through the COP 11 form and find that P is quite happy where they are. So it may be that that's not available. If at all it is a contentious case, then speak to a lawyer about it and just find out what they think. Other sources of funding, as I was saying, sometimes people end up paying their own legal costs, and that is, I don't like it, but sometimes it is the case. Where I say other sources, question mark, sometimes where something has happened where it is really clear I don't know. There are cases where you ask the legal aid agent, the local authority, if they will pay the fees. They're few and far between, and they don't have to do it. But occasionally you find one where, so for example, it's going to be really costly, but the person doesn't have, it's going to wipe out someone's savings, but they're not eligible for legal aid. It might be in that circumstance, but very often it's going to be out of the person's own funds or it's legal aid. Points to consider when you are thinking about legal aid and costs. Changes of funding due to changes in circumstances. So the case starts off as a, the case starts off under section 21A, non-means tested legal aid, dead straightforward. You get to a point where the person's going home for a home trial and the standard authorization is no longer in place. Means test needs to take place of whether that person's still eligible for legal aid. You might find that they're actually not, and the Court of Protection case continues, but suddenly they're paying privately. You might find that actually they are, but you've got real difficulties in getting hold of their bank statements and stuff, because their finances aren't managed by the council, they're managed by their husband who lives in the same house but is actually a different party to proceedings. Can be really tough, but it is important to think about whether those changes mean a change in funding. If you've got a solicitor, they should be picking up on those things. Difficulties obtaining information I've talked about. I've also talked about that court order right at the beginning of cases, which allows a litigation friend to either incept funds from the bank to pay legal fees or investigate whether the person's eligible for legal aid, sign a legal aid form. If they are paying privately and you're not comfortable in agreeing what the costs are with the solicitor, and the solicitor should always mention this to you, the court can assess the fees at the end. And I know when the official solicitor acts as litigation friend, my understanding, last time I discussed it with anyone there, is that if the solicitor incurs more than £3,000, they always ask for the court to assess the fees rather than them making the decision that that's an okay fee. Solicitors should be charging a fair price, and the rates are set by the court. But if you don't feel comfortable, no solicitor should be saying to you, should be in any way querying that. If you feel like it should be assessed by the court, then that's okay. And I think that's the end of my slideshow. Any further questions that you want to ask me right now where I haven't addressed anything? That is the end of my slides, apart from one more that's just got our beautiful faces on of our department. Well, that's nice. So I've just shared, just to say one further thing. If you are ever stuck, or you want to instruct us, or you think there are things you want to think about, you don't know whether to bring a case before the court, you don't know. I think I'm sharing that again. I hope so. Yeah,
you are.
The person's going to be eligible. You don't know if there are cost considerations. You have been appointed in a case where it's said to be contentious, but you think actually it might not be. You're very, very welcome to give us a call. It's just me talking consistently today. I'm sick of the sound of my own voice. But there are a number of us here that can help. And you're welcome to just give us an informal call if you want to. And so that is the end of it today. We'll send you the slides. We'll send you the recording of me whittering on today that you can share with your colleagues if they want to watch. And you're very welcome to send us any feedback or any questions that come up afterwards. Rethink asked me to run this today, and sorry, I have overrun by 10 minutes and I apologise for that. Rethink asked me to run this today, and I know a couple of years ago I did a course for people, particularly on that bit of eligibility where it rubs up against the Mental Health Act. If there are things that you think your organisation could do with specific training on, let me know. I'm happy to have a look. It helps me as well as it helps everybody else. So hopefully that's been helpful, and thank you for coming. Have a nice day.